My name is Gaila Rudy Fraser, and welcome to the ILO Masterclass on Fairer Recruitment. Before discussing the monitoring and enforcement of recruitment regulations, let's first establish why recruitment needs to be monitored. Abuses endured by workers, both migrants and nationals, that result from the recruitment process engaged in by unregulated agencies and other unfair intermediaries are heavily documented in reports by human rights organizations, by the media, governments, and academics. Unscrupulous recruiters may be involved in several forms of abuse that all have negative implication on the human rights of workers. High recruitment fees charged to workers, deception about employment contracts, retention of passports and personal identification, illegal wage deductions, and threats, to name a few. In the most extreme cases, abuses amount to trafficking and/or forced labor. Not only do these abuses severely affect workers' rights, but they can also affect both the reputation and operations of their employers. Therefore, the monitoring and regulation of recruitment practices is critical. Governments enforce national legislation as a means of balancing the interest of private agencies with the need to protect the right of workers. The starting point for all regulation is to determine the legal status and conditions for operating. In particular, there are three basic models of regulation. Prohibition, where private recruitment agencies are banned from the labor market, and in which case public employment services may play a greater role. Licensing, where agencies must request a license that is granted when certain conditions are met. And registration, where agencies are registered in the same way as any other business and are subject to controls. In this context, governments are required to develop a monitoring and enforcing mechanism that ensures that all market actors meet the requirements. When we talk about the monitoring and enforcement mechanisms, licensing fees should be part of it. Monitoring and law enforcement can be carried out by the licensing authority or by regular or specialized labor inspection units, and in the case of criminal activities, by the police. In order to operate effectively, law enforcement officials must have clear benchmarks and standards against which the performance of employment agencies and other type of agencies can be evaluated. The conditions and criteria stipulated in the license can be used for this purpose, along with codes of conduct and relevant labor and immigration laws. We can identify two alternative ways of monitoring agencies' activities. Field audits, for example, through regular inspections. These are usually unannounced, as they often are the result of a complaint or report on violations of the regulation. However, they require sufficient financial and human resources, which may be limited in some countries. And the most common, the desk audit, that are carried out during the application procedure for licenses. Upon request, in many countries, agencies are obliged to provide the competent authority with additional information, and if the information is not sufficient, a regular inspection may be necessary. Additionally, another way of directly monitoring the recruitment and placement activities is to require agencies to supply copies of employment contracts. This can be a useful tool, especially for recruitment abroad. In line with the ILO Private Employment Agencies Convention from 1997, the number 181, in cases of non-compliance with recruitment regulations, governments are required to impose sanctions. Measures can range from minor administrative to severe penal sanctions. In some cases, the enforcing authority could give appropriate advice to the employment agency on how to rectify their procedures or practices. But on the other hand, administrative sanctions include the possibility of withdrawing a license for a period of time or indefinitely. In addition to imposing sanctions, some countries have also introduced incentives for compliant employment agencies. Absolutely. In cases where workers have been victims of abuse or malpractice by a private employment agency, it is necessary to set up adequate complaints procedures to identify and examine allegations of violations. Unfortunately, workers can face several challenges in the area of access to justice: high cost of legal assistance, fear of retaliation, and for migrant workers in particular, discrimination, irregular status, and language barriers, to name a few. Given the forces of demand and supply at play, policing by states is not sufficient on its own. Therefore, enterprises have put into practice self-regulation initiatives. Industry associations have been formed and have developed voluntary codes of conduct. In addition to voluntary codes of conduct, some private employment agencies have favored more competitive systems of self-regulation, such as rating or labeling. Workers' organizations are key actors in a multi-stakeholder landscape to combat unethical recruitment. They play a crucial role as capacity builders and policy influencers, and in monitoring and oversight. In collaboration with the Labour Administration system, they can observe whether basic recruitment principles are respected and check that complaint and dispute resolution mechanisms do function adequately. Workers' organizations can also engage in public and worker awareness campaigns. In the same line, some NGO mandates are also encompass activities related to the enforcement of fair recruitment, such as awareness-raising initiatives targeting the public, as well as workers and employers, the development of ethical recruitment and hiring frameworks and codes of conduct, and the publication of surveys reflecting the experience of workers. Employers also play a critical role in ensuring due diligence in their business operations, including auditing their recruitment service providers. In conclusion, governments, in their regulatory capacity, play a key role in improving the efficient functioning of the recruitment landscape by putting forward monitoring and enforcing mechanisms in order to prevent abuses and protect workers' rights in the recruitment process. Nevertheless, on the other hand, important challenges and barriers persist in terms of access to justice, in particular for migrant workers in destination countries. Here lies the importance of all actors in the recruitment landscape, including employment agencies, trade unions, NGOs, and other social partners, to continue playing a vital role in promoting a regulated, fair recruitment industry for the benefit of all parties involved.